All right, good morning, everyone, and welcome to this second Growth Perspectives webinar. Today, we will be looking at the topic of international trade treaties and innovation, and it's going to be an exciting webinar. We live in a dynamic, globalized and interdependent world that is largely characterized by trade treaties and international investments or foreign direct investments which they enable. It is in this context that, for instance, Chile, South Korea, and Singapore have transitioned to become high-value countries. And this high-value country status is based on the World Bank's classification system. Such countries were able to transition not only because of their strategic geographical locations, but more so because of their purposive structuring of favorable trade treaties and active utilization thereof, creation of research-based cultures, and execution of innovation-driven trade. As far back as the 18th century, Benjamin Franklin, one of the founding fathers of the US, suggested that no nation was ruined by trade. More recently, though, scholars, policymakers, and industry executives, and even activist groups have challenged this notion. They have insisted that for trade to be sustainable and mutually beneficial, it must be free and fair, and free from fear. We at Growth Perspectives share these sentiments. In fact, we have gone further to suggest that the next economic frontier will be largely similar to the previous one, in that countries will transition to develop country status, not by international aid, but by international trade powered by innovation. Considering this, I asked the question, how can the largely low and middle income countries in the Caribbean and Africa use external trade treaties, for instance, the Economic Partnership Agreement with the European Union and the Caribbean Basic Initiative with the US, as well as other internal trade treaties such as the African Continental Free Trade Area and CARICOM Single Market and Economy? How can they use these treaties to stimulate homegrown and foreign-linked innovation? We have invited Dr. Dominic Dagbanja, a lawyer and eminent scholar currently based in Perth in Western Australia. And by the way, it is now after 10 p.m. in the night there, so we're really excited to have Dominic with us to help us answer this question and to shed light on the critical yet understudied issue of why many, if not most, developing countries fail to optimize on the trade treaties which they sign, be they with developing or developed countries. In true Growth Perspectives style, we have invited Marcus Goffe, another lawyer and scholar, to moderate this highly anticipated session. The basic idea is that one lawyer will ask the other lawyer questions. And of course, the rest of us will get to be the judge. Finally, let me now say a few words about these gentlemen before sort of handing over to Dominic, who will commence with his presentation. So I'll now bring up a profile of both their Growth Perspectives profile on the screen so that you might see them. Excuse me. Un momento, as we would say here. Let me just bring this up real quick. One moment. All right, so there's just so much to say about Dominic and Marcus, but we want to focus on the presentation today. We want to give them enough time to talk. Marcus is going to be moderating and Dominic is going to be presenting. So here we have their Growth Perspectives profile. Dominic is a PhD, of course, from the great University of Auckland. And he has worked on about 4 or 5 continents, just too much to mention here. In terms of growth perspectives, he specializes is in our strategy practice and specializes in international law and trade treaties, and helps us out with our global strategy, helps out our clients in terms of their global strategy work. He has over 25 years legal experience in practice. He has worked in the US, worked in Africa, worked in Europe, worked in UK and Australasia. And we are delighted to have Dominic with us. Dominic would have also studied in the US at George Washington University, at the University of the Pacific. He did 2 degrees in Ghana as well, an LLB, which he graduated top of the class. He also did a BL in sociology, so he brings as well that sociological perspective to his work and practice. Currently a senior lecturer in international investment law at the University of Western Australia down there in Perth. And he has worked as a postdoctoral scholar at the University of Manchester in the UK, worked in New Zealand at the University of Auckland, and worked in so many other places. Dominic has published over 40 academic articles and books, and his most recent book is actually the subject, or partially the subject of our discussion today. That book was published only last month by University of Oxford Press. So excited to have Dominic, and really looking forward to his presentation. Let me tell you a little bit about Marcus Goffe, who is likewise a technical consultant with GP, but Marcus is in our innovation practice. Marcus has worked in the Caribbean. Marcus has both a PhD and LLM degrees from the great University of London, the Queen Mary College, and he has practiced as an attorney and legal consultant for over 18 years, worked in academia, as well as in practice. Most recently, he was the deputy director for the Jamaica Intellectual Property Office. And through his work and the work of others at that institution, they would have helped Jamaica transition to become one of the leading, I think in fact, the leading country in the Caribbean as far as the Global Innovation Index is concerned, the ranking on the Global Innovation Index. And in some ways have outperformed, punched way above its weight. And so Marcus has contributed much to innovation policy, and we're delighted to have him in our practice, helping us with innovation, enabling and patenting considerations. He has done a lot of work for government agencies and international agencies, as have Dominic, and these gentlemen are distinguished in their fields, and so we are delighted to have them. I will leave it at that. I invite you to hop onto our website if you want to learn more about them, or reach out to us at info@growthperspectives.co. You might also ring us at 876-402-7114 for more information and for consultation with these gentlemen and others in our innovation and strategy practice. So without further ado, I now hand over to Dominic, Dr. Dominic Dagbanja, who is, as I said before, currently based in Perth, Australia, but is originally from Ghana. So he's a part of the African diaspora, as we all are, as most of us are. So delighted to have you, Dominic. Over to you. Thank you.
Okay. Let me just bring my PowerPoint and then we begin. Let's see. Okay. Is this fine for everybody? Okay.
Yes, it's good.
Yes. Yeah, okay. All right. So let me thank Dr. Joel Allen for your very kind introduction. and also to say thank you very much for the opportunity to be able to engage with brothers and sisters in the Caribbean on this important topic of international investment agreements, business innovation, and regulatory authority. Now, some of you may not know that Dr. Allen and myself were colleagues at the University of Auckland around the same time, and I left and he followed. And I'm very happy and pleased that he went back home and together with others, he set up Growth Perspectives, which I believe is going to make contribution to policy discourse on its area of specialization. And I'm happy to be part of the organization as a technical consultant. I believe that African development, the Caribbean development is in the hands of Africans, the people in the Caribbean. And so we need to pool our resources and capacity together and share ideas. So let me proceed to give you a take-home point. These days, I try to make sure that in my presentation, I make certain key points so that people can go home with a point at least, and they don't waste their time participating in the discussion. So the first point that I want to make is that international investment agreements, by providing the necessary legal protection for investment, for trade, creates a very conducive legal environment for investment. But they also have the effect, the other side of it, of severely constraining the capacity of states to discharge their duties to protect the public interest and advance their national development goals. So you can see the conflicting role of trade agreements, investment treaties. And I also seek to argue that the constitutional right to development and the corresponding duties of African states, Caribbean states, do, or at least should place limitations on the competence of African Caribbean states in concluding investment treaties that limit their authority to regulate in the public interest or to advance their development goals. And then I make a third point that African and Caribbean governments should develop business innovation policies and programs that will help build the capacity of their domestic businesses so that these states can reciprocally benefit from investment treaties. And I will elaborate on these main points later. So the presentation forms part of the larger body of research that I do in terms of the intersection of domestic law and policy. And my research focuses in particular on the limitations of investment treaties on states' regulatory authority. I also look at the extent to which the duties of states, in particular African states, and the national constitutions limit their authority when it comes to the type of investment treaty terms or even trade terms that they can agree to under these international agreements. And I also do my analysis from the perspective of international law. And so I developed in my book what I call the imperatives theory, where I look at I argue that the obligations of states arise from not only domestic constitutions, but also under general international law, and that their obligations are deriving from national constitutions, general international law should limit the type of investment treaty obligations that they can undertake in international economic relations. So let's look at the scope of what I intend to cover. So I will cover the standards of investment protection and business innovation. And by the end of the presentation, we should be able to address the question, how might investment treaties serve as a catalyst for business innovation? The second area that we will cover will be the right to development. And I argue that the right to development comes from the national constitutions. There is corresponding duty on African states, Caribbean states to regulate in the public interest. And the question is, how might investment treaties stand in the way of these states' duties to pursue development policies of their choice? And these presentations are reflected in particular in my book, The Investment Treaty Regime and Public Interest Regulation in Africa, published by Oxford University Press this year. In particular, you will want to read from pages 263 to 367. So let's look at the question of why are countries concluding investment treaties or trade agreements? Why are they concluding that? I think the answer seems to be obvious, isn't it? That the argument is that, and the conventional argument, in fact, I should qualify that, is that investment trade leads to development, and that investment treaties, trade agreements can attract investors, traders, and therefore a large number of countries are parties to this huge international investment agreement. Today, if we look at the World Investment Report, it indicates that there are over 3,288 international investment agreements. And some of these are contained in bilateral investment treaties. Others are contained in free trade agreements with investment chapters. And so as revealed by, if you look at the text of investment treaties that African countries, Caribbean states have concluded, you will see that, at least as revealed from the preambles, they have signed on to these agreements because they believe that investment is necessary for their development. So they have concluded these agreements in order to attract investment. And so let's look at now, we will tend to look at what are the obligations states undertake under these investment treaties, and what are the implications for their regulatory authority, and what are the relevance of these terms for business innovation. Generally, we find under these agreements that they contain various terms, including terms such as the fair and equitable treatment standard, full protection and security. Sorry.
Oh, Mr. Scott. Not too bad. I have a miserable time.
I think there's some noise in the background. I thought it was directed to me, sorry. So there are various terms that are contained in these treaties. We have the fair and equitable treatment standard, the full protection and security, national treatment, most favored nation treatment, expropriation, performance requirements, and the umbrella clause. And of course, there are provisions for the settlement of disputes by international arbitration. We do not have the time to to look at each of these, and I'll only look at the fair and equitable treatment standard just to illustrate the nature of the legal protection that this agreement provides for investors and how that might be relied on to advance business innovation. So in terms of the fair and equitable treatment standard, it has been interpreted by arbitral tribunal to contain a number of elements, and they include protection of the legitimate expectations of foreign investors, provisions relating to transparency, for example, that the rules and regulations governing, domestic rules and regulations governing investment should be publicly accessible and available. The standard, the fair and equitable treatment standard, has also been interpreted to cover arbitrariness, and discrimination. So states should not arbitrarily discriminate against foreign investors, that they should not deny them justice and procedural fair process, that it prohibits bad faith, stability, predictability, and consistency. For example, that if you make your legislation, you must make sure that the legislation, you do not change it in the middle of the investment to the detriment of the foreign investor, which is similar to stabilization clauses that countries sometimes agree to. The fair and equitable treatment standard has also been interpreted to include the legality and compliance with contractual obligations, proportionality and reasonableness, and freedom from coercion and harassment. So as you can see, this is a very elastic concept in international investment agreements that is intended to provide foreign investors with all sorts of protection that will allow them to be able to operate the way that they need to operate to advance their business objectives. And we can look at the specific case of legitimate expectation of investors as an element of the fair and equitable treatment standard. And a case that we can use to illustrate this point is the CME against Czech Republic. And in this case, a license for television broadcasting was granted, but was subsequently revoked based on a change in the relevant law governing the media industry. Now, the new legislation required partnerships between, partnership between the local domestic businesses and foreign investors, instead of just allowing a foreign investor to operate in the industry. So the revocation of the license meant that the foreign investor could not operate the business. And the foreign investor brought a claim against Czech Republic, claiming a breach of the Czech-Netherlands bilateral investment treaty, which had provided for fair and equitable treatment standards. It was held that the Media Council breached its obligations to provide a foreign investor fair and equitable treatment by taking away the legal basis on which the foreign investor entered into the market, which means that there was a promise of legal protection. The foreign investor relied on that legal promise to enter into the market, and having taken it away, it's like the foreign investor was stepping on something and you've taken it away, the foreign investor will fall. So the legitimate expectation of the foreign investor that the law will be stable had been taken away, and it was held that the fair and equitable treatment standard was breached. Another case that we can look at is also on the legitimate expectation of foreign investors, which is an element of the fair and equitable treatment standard, is the MTD equity against Chile. Now, in this case, the investor was awarded a contract to invest in the construction of a planned community. And having commenced the construction, the government subsequently issued a stop order, arguing that it was not consistent with the project, was not consistent with the zoning regulation in the particular location of the project. And so the foreign investor brought a claim against, Chile under the Chile Bilateral Investment Treaty, which provided for in Article 2.2 that investments of investors of either contracting party shall at all times be accorded fair and equitable treatment standard. Again, in this case, it just meant that the state provided an attractive investment for the foreign investor to go in. The foreign investor relied on that environment, that legal protection, and having entered, the state couldn't be changing the law. And in this case, the arbitral tribunal said that the state was acting inconsistently, because having given the impression to the foreign investor that their investment will be protected, the state could not go around to take away the basis on which the foreign investor enter for the market. So as you can see, this could raise very serious concerns for the authority of states to regulate or to change laws after foreign investors have entered into the market. So the question is, how does this protection, as reflected in the very brief illustration we've looked at in terms of the fair and equitable treatment standard, with specific reference to the legitimate expectation of foreign investors, provide a basis for innovation? As you can see, even if investment treaties contain just the fair and equitable treatment standard in itself, I think that there will be an assurance to foreign investors that they have the international legal protection to be able to do business in whatever location that they have chosen to go. But the question is, how does that protection provide a basis for business innovation? I've learned from these sources that business innovation is about how a business pioneers a process, a product, or service in an industry by improving upon or completely redesigning the service or product. But I've also learned that business innovation is also about venturing into new markets and new partnerships and relationships to advance the operation of the business beyond its immediate environment. And in that context, international investment agreements provide legal comfort, legal protection, legal security for investors to be innovative, because their ideas will be protected under international investment agreements. So innovation is key to creating new products, entering new markets, but without the assurance of legal protection, your business interests may not be protected. And international investment agreement provide opportunity for businesses to go and wherever they want to do business with the assurance that their business ideas, their business innovations, products, services will be provided. So in that sense, there is a close association between international legal protection of foreign investment and business innovation. But I think that in the context, let me contextualize the conversation in the context of African states, in the context of Caribbean states. And in this regard, I wish to recommend that there is a need for governments in Africa, in the Caribbean, to provide support for their businesses, particularly in the area of research and development. And we can learn, for example, that direct support in the form of grants can be important in promoting research and development, which can promote businesses. And we learn from the the Organization for Economic Cooperation and Development, OECD, that their countries will usually provide direct support measures for private investment in research and development. For example, Australia's Green Car Innovation Fund at some point provided assistance in the form of grants to Australian companies for projects that enhance research and development and commercialization of technologies. And the program was directed towards projects that could significantly reduce greenhouse gas emissions or lower fuel consumption in passenger motor vehicles. Again, the Netherlands Innovation Credit Scheme was also launched some time ago to address the problem that small to medium-sized businesses face when it comes to financing. And so with this some form of support, businesses are able to innovate. And the point that I seek to make, particularly in relation to the Caribbean and African countries, is that these agreements that we sign are supposed to be reciprocal. They are supposed to bring reciprocal benefits, that our businesses will go there and do businesses. Businesses from there will also come and do business in Africa, in the Caribbean. And so I think the reciprocal benefit that is supposed to come from this agreement is less likely to be received unless we have the capacity to be able to do business in their environment too. And that is why I think providing the necessary support for African businesses, for Caribbean businesses, to be able to invest, not only within, say, among African Caribbean countries, but also outside, it is so crucial. Otherwise, there is no point in being a party to these agreements. So government needs to commit themselves in building the capacity, and particularly because international agreements, investment agreements come with the capacity of foreign investors to be able to challenge the decisions of domestic, their host countries, such as we have looked at in the case of, the fair and equitable treatment standard. So it is crucial that we develop local capacity by providing support in the form of research and development so that relevant research can be done to build the capacity of those businesses. And of course, non-research related support as well can be given to businesses to grow their capacity to invest in other parts of the world. Now let's shift. So we are looking at the connection between business innovation, investment treaties. Let's shift now and look at how these agreements, in spite of their importance in leading to business attraction, business innovation, providing protection for foreign investors, can at the same time limit the capacity of states to exercise their regulatory authority. And this is very important for me, and I think it is important for African states, Caribbean states, largely because, as I have said, it seems we invest less in the countries that we sign these international agreements with. And there is also the risk that African countries, Caribbean countries, will get sued in international arbitration, which come at huge cost to the public expenditure. So, as I said, the primary intent of the framers of various, I haven't said this before, that the primary intent of the framers of various constitutions in Africa, and I've looked at the Constitution of Jamaica, which I will refer to later, is to provide a legal basis for African states to advance, Caribbean states to advance the development of their people, to achieve the right to development. And African constitutions evidence what I call the constitutionalization of the right to development. And the right to development and corresponding duties of African states, Caribbean states, are central in the constitutional framework for governance in this part, in our part of the world. And the question arises whether or not, given their constitutional duties to advance the development of the people, they can choose to limit their capacity to perform those duties. And we can look at the Constitution of Cameroon, for example. It provides for a duty, it imposes duties on the councils and regional and local authorities to promote economic, social, health, educational, and cultural development. So when we look at this constitution, we can argue that the Constitution of Cameroon recognizes the right to development and imposes duties on the state of Cameroon to advance the right to development. If we look at the Constitution of Egypt, it talks about, in particular, Article 27 talks about the idea that the economic system should achieve prosperity. And therefore, it talks about development and social justice and so forth. And similar provisions are contained in other constitutions. The Constitution of South Africa provides for the right to clean environment, a safe environment. I looked at the Constitution of Jamaica. It talks about that the state has an obligation to promote universal respect for and observance of human rights and freedoms. Article 13 talks about the right to enjoy a healthy and productive environment free from injury or damage. And that Parliament does not have the right to take away these constitutional rights. So as you can see, these references allow us to conclude that the framework for constitutional governance in Africa, in the Caribbean, at least if we're limiting ourselves to the Constitution of Jamaica, is to provide a framework for the advancement of the right to development. And so these could be described as development constitutions. So one of the ways that African countries, Caribbean countries seek to achieve this, to advance the development goals, is to sign on to investment treaties in order to attract investors who will come and contribute to the national development objective. And yet, the adoption of policies that are intended to advance national development can be challenged in international arbitration. So therefore, there seems to be a conflict between the search for development using investment treaties and the capacity of African states, Caribbean states to advance their national development goals, developing general development policies. And so the literature has been replete with arguments to the effect that there has been a constitutionalization of the regime for foreign investment protection to the extent that they leave no space to talk about social justice, to talk about environmental justice, because when states adopt policies that are supposed to advance national development goals, such as the protection of human rights, the protection of the environment, they get sued in international arbitration. And if you look at my book, I've listed a number of areas where regulatory measures have been challenged in international arbitration, including, for example, regulating ownership in joint ventures in the interest of global populations, the abolition or modification of tariffs set in contracts for utilities and environmental measures. And we can cite the example of Zimbabwe and South Africa, which implemented various reform policies, which were aimed at empowering Black people. And those measures were founded under national constitutions. And yet those measures were challenged in international arbitration, so that the obligations of the obligations of governments to adopt policies to advance their development and the national constitution can actually be challenged in international arbitration. And so that is a matter of concern for states. Again, there are various provisions in investment treaties that are not also consistent with the idea that they can lead to development. For example, performance requirements in investment treaties. And performance requirements in investment treaties seek to limit states from being able to impose certain requirements for foreign investors. So, for example, we can look at the Jamaica-United States Bilateral Investment Treaty, which says that neither party shall impose performance requirements as a condition of establishment, expansion, or maintenance of their investments, which require or enforce commitments to export goods produced, or which specify that goods or services must be purchased locally, or which impose any other similar requirement, other requirements. So if you cannot impose, for example, export requirements on foreign investors, maybe you want to now grow an export-led industry, this environment, and you cannot impose those requirements, or that certain goods and services are needed and you want foreign investors to import them. By agreeing to performance requirement provisions in investment treaty, Jamaica, for example, will not be able to make those impositions on foreign investors. So while that may be necessary for business innovation and development, it also means that the capacity of Jamaica to be able to regulate foreign businesses the way that it wants to advance its development goals cannot be exercised without being sued in international arbitration. So I think I'm getting to the end now, and let me draw a conclusion. I haven't checked the time, so I suspect that I may have overspoken in terms of the time. But this point that I'm seeking to make by way of conclusion is that there is the need for investment promotion policy to be aligned with the overall development policy as reflected in national constitutions in Africa, in the Caribbean. And I also seek to propose that in order to enhance the coherence between investment promotion obligations and national development objectives, the constitutional duties to make and implement development policies must limit the capacity of African states, Caribbean states, when it comes to the type of treaty obligations that they can undertake in international investment law. So I think that I should bring the conversation to a close now. Maybe there is a basis that we can engage in, a more productive conversation. Thank you very much for listening.
Yeah, thank you very much, sir. Yes, Dr. Dagbanja there, sharing with us really some insightful and interesting perspectives, from a developing country, of course, context. So thank you very much for sharing, those cases and really addressing the conflict, right, that sometimes presents itself to developing countries when dealing with potential or actual investment treaties, right? All right, so I am Marcus Goffe. I'm the moderator, as I was introduced earlier, and I'm really pleased to be here as well with Goffe Perspectives this morning to look at this interesting topic, and of course with my brother from across the Atlantic. So it's nice to have our fellow Africans here with us. So the floor is open. I'm going to open the floor. Of course, I have some questions to ask too, right? But I do want to ensure that we also facilitate questions from the audience as well too, So maybe I will kick it off, and then we can go into some further discussion and questions thereafter, right? Mm-hmm. I know Joel mentioned some loyal questions, right? But don't worry, I won't cross-examine you.
Yes.
So I think it's really, as you say, challenging, when we talk about free trade and fair trade, right? And how that has, through globalization,
those
really.
Pillars, those small pillars, you see them on the road as well.
I could ask, thank you. Right. Has presented challenges to us in the diaspora, over some time, and through globalization has really facilitated access to developing country markets, right? With, of course, promises, as you say, of reciprocity that have not always panned out, and the reality is that many of those developmental aspects and objectives of these treaties have not been met, So that's a very real conflict, of course, because of the imbalance in bargaining power in these treaties oftentimes, right? That then, as we know, many of the developed countries roll out these treaties like set templates. They're already drafted from capital, and they're then sent out for developing countries to add their signatures to. Yes, there may be some negotiations still, but oftentimes, there's set templates that have been, of course, designed primarily to facilitate access to markets. So how would you, Dr. Dagbanja, say that some of this conflict, can be resolved, bearing in mind, let's say, that the bargaining power, the need for aid, and for investment oftentimes leads developing countries to feel vulnerable and to feel as if they don't have much choice, What would you say about how we can strengthen that resolve?
Yes, it's a very, very huge question, and I'm sure we will not exhaust discussing the issues here. How do we resolve the conflict between the development objective underlying this agreement and the idea that they tend to limit the pursuit of policy measures that are designed to address these concerns? Part of it will be, maybe there will be questions that will allow me to be more specific, but part of it will be to include clauses, enforceable clauses that preserve the capacity of states to adopt measures, general measures not intended to harm foreign investors without being sued in international arbitration, or that if they are sued, then states can safely rely on them to defend those measures. Again, should foreign investors also take the risk inherent in choosing to do business in a foreign land? I think international investment agreements in particular seek to insulate foreign investors for all forms of losses arising from the exercise of the regulatory authority of states. And yet, the very function of government is to make laws, is to make policies, and to implement them. So we need to find a way that ensures that foreign investors take responsibility for doing business in a foreign land. Some measure of risk need to be taken by foreign investors in operating in foreign lands. I think that is generally how I will respond to this question. Thank you.
Okay. So you, of course, also touched on shortly before you concluded the example of Zimbabwe, you know, and how national policy, right, can again be hampered or be at odds with investment treaties, and how maybe those kind of, for want of a better word, maybe it's not really protectionist, it's more, I would say, in terms of maybe facilitating fair and equitable treatment of persons, you know, in national jurisdictions, how those have also been challenged, right? So are there any examples of situations where developing countries have been able to facilitate, you know, that kind of social investment alongside, you know, the foreign investment pursuant to the treaties, and still be able to do so without falling afoul of the standards of investment protection?
Thank you. I think the cases where, well, I've looked at the cases. There are about 1,190 known investor state cases against states. And I think the last time I looked at the data, about 100 or so of them have been brought against African countries. I've not specifically seen the Caribbean countries that have been parties to these claims. And the measures that have been challenged in these cases generally are not necessarily development-related measures as such. But the imposition of tax, well, tax is a development tool. The imposition of tax, and in particular case of South Africa, because South Africa has preferential procurement policies, and procurement in South Africa is supposed to be used as a tool to address racial injustice arising from apartheid and so forth. Zimbabwe came up with a land reform policy, which said give the land to the people, which essentially means that the white farmers who were the commercial farmers and were more or less using the lands had to give up those lands to the Black people or the owners of the land. And so these were cases where there was actually a direct clash between measures that were intended to bridge the inequality between, say, a white population and the Black population came in conflict with investment treaties. There are other cases where various forms of regulation, such as the withdrawal of permits and so forth, have been challenged in international arbitration. And I'm wondering, maybe it has not reached a stage where you can say that, well, investment treaties have actually come to take away the development that developing countries are looking for. And so I'm not sure, I haven't come from a specific case where a country in Africa, for example, was said to have managed handling the investment treaty framework along with the pursuit of its own policies in a manner that will set as an example. Perhaps South Africa provides an example in the sense that what South Africa sought to do was to terminate a large number of the investment treaties that it signed, and then came out with an investment act. So perhaps it's actually, I analyzed South Africa in my book. So South Africa provides maybe a good template for other African countries because it terminated some of a reasonable number of the investment treaties and then came out with the investment legislation, which now even emphasized that investment disputes ought to be settled domestically in domestic courts or through domestic arbitral process and so forth. And there is no indication that South Africa has lost attracting foreign investors because it terminated a large number of investment treaties and came out with, a domestic legislation as the primary source of protection for foreign investors. But again, South Africa may not be, South Africa still has a number of those treaties in place. So there remains a potential conflict between the investment treaty framework and the South African domestic legislation. But I think that it provides a good example if I were to recommend any country at all in Africa as a reference point. Thank you.
Okay, thank you. Thank you for that answer. Interesting, very interesting, I think that when we think of, how the national laws can be used in that way, is it then that the national law has sought to divest the parties of the option to go to international arbitration, or is it that they just require a national route first, and then wouldn't that national law potentially still be challenged if it's at odds with the treaty?
Yes, and that's why the reason I said that there remains a conflict between, say, for example, the South African domestic legislation, I think the title Protection of Investment Act or so, and an investment treaty framework. I think the preference is to resolve through the administrative process. And if that fails, then the preference is for domestic arbitration rather than international arbitration. And I do think that if institutions are strengthened domestically, they can resolve investment disputes. Foreign investors are looking for effective mechanism for resolving disputes between them and host states. Of course, the historical development of these treaties is post-colonization. So they are just another new form of colonization where the very states that gain independence stand around to sign investment treaties where they ceded more or less their sovereignty. So, so yes, there remains that potential conflict because the principle, as we learned under the Vienna Convention of the Law of Treaties, is that you cannot cite domestic law as an excuse to observe, for failure to observe an international obligation. So that conflict is not necessarily effectively resolved. As long as you remain party to some form of an international treaty, the potential conflict between domestic law and international law will arise. But I think that South Africa has made a very good first step in trying to address these conflicts, which we can learn from.
Okay. All right, I'm going to ask one more question before I again go to the floor. So on the converse side, right? Is there a large number of situations where states, right, or communities within states have taken companies, to arbitration over the breach of investment treaties?
Yeah, thank you. It's a very important question to ask. And I'm not just saying so as the usual way of saying things. The truth of the matter is that investment treaties are designed to provide legal protection for foreign investors. Maybe there is one example that I don't remember, but the point is that investment treaties are designed to provide legal protection for foreign investors. And that is why I was arguing that given the nature of the legal protection that they provide for investors, then they are an important tool for innovation because your business will be protected. Now, because of the way they have been designed, they are one-sided, such that I don't remember actually any case where a foreign, the point is that there's no obligation under investment treaty, for example, for a state to take on a foreign investor in the first place. Investment treaties impose obligations on states. And so states don't have. Somebody said it is a textual void in the sense that what will the state rely on to be able to sue a foreign investor in international arbitration? There is nothing. So I think that is where we need to address the issue, that we need to enforce, and that is the argument that I make, that we need to impose enforceable obligations on foreign investors in investment treaties so that they can be held to account.
So it's one that these treaties are really imbalanced, and one may say you have concepts of unfair contract terms and such, in these circumstances, and it's really unfortunate. Oftentimes, I say that our hands are tied as developing countries in these circumstances. And then even, as you mentioned, innovation, I think innovation too gets caught in that, conflict sometimes too, because of course, with innovation, there's a lot of value and potential. Sometimes investment is made, sometimes the investment is little compared to the extraction that can take place, from our economies and from, of course, our creativity in the developing world, All right, I'm going to open it to the floor. So please, if you want to ask a question or make a comment, please feel free to raise your hand, and we can do so. And we look forward to having your input, please. Any questions or comments for Dr. Dagbanja on what he has said, which has been really, really interesting on many different levels. So the floor is open, please. Any questions, any comments from any of our participants? No. Okay, all right. I guess they're enjoying the discussion. So, until then, I can also, go and continue discussing with you, Dr. Dagbanja, the issue of innovation. Right? Yeah. Is that a voice I heard? Please go ahead. If you wanted to say something, please go ahead. Yes, sir.
Thank you, Professor Goffe, and that from down and excellent presentation. I am digressing from what you probably have discussed to some extent, but my issue is with bauxite mining in Jamaica. And I don't know, I saw the Constitution, he mentioned something about Article 13, healthy, being exposed to healthy lifestyle or whatever, guarantee that sort of thing. And I'm looking at a situation in my neck of the woods in South Manchester where a haul road is built within 300 feet of a healthcare clinic. And I wonder, just food for thought, so to speak, in terms of what is guaranteed under the Constitution and what the private sector and the government, since the government has a 49% interest, I think, in the bauxite companies. So it's the state, and I don't know what your thoughts are on it, Professor Goffe. And
very relevant question. It's not a digression at all. I think it's a very relevant question. And I know Dr. Dagbanja mentioned the right to health and environment and these conflicts. So Dr. Dagbanja, yes, this is of course a long-standing issue, for many countries in Africa, in the Caribbean, in terms of extractive industries, and of course the treaty framework, and then the human rights of individuals, who of course are almost never consulted, when these decisions are made. So what would you advise in that circumstance that could, lend some assistance to such communities?
Yeah, thank you. I don't think it's a digression at all. On the contrary, it centers right on what we have been saying. And so I'm not here to sell my book, but I think these are the things that I research on. That if I look at, I analyze the various constitutions in Africa, Egypt, Cameroon, South Africa, Ghana, Nigeria, Kenya. These were the 2 countries that I studied. And I look at the various provisions relating to the protection of the environment, relating to human rights, and so forth. And I analyze and look at situations where, in fact, these countries are, places where there's a lot of investment in the extractive sector. Nigeria is notorious for that in particular. And you can imagine the oil industry and the nature of environmental destruction, environmental damage in Nigeria. And yet the Nigerian constitution provides for a legal basis. And in legal terms, the constitution is on top there in terms of the hierarchy of norms. It is a reference point for all legal norms. And yet we conclude agreements that will more or less rubbish national constitution. So it is a very legitimate concern that you are looking at the extractive sector in Jamaica, in the Caribbean, other Caribbean countries generally, and the protections that their constitutions provide for environmental protection, for example. And so my point is that when states are concluding this agreement, they usually don't have any reference to their national legal obligations as such. And so they go and sign on to agreements, the terms of which are inconsistent with their domestic policy, their domestic, their national constitutions, and so forth. And that is why I try to theorize around the idea that the validity of these agreements, these international agreements, ought to be judged in terms of whether or not the state had the capacity to be agreeing to the terms in the first place. Does Jamaica have the constitution, the capacity, if you look at the right to environment, which the constitution specifically says that Parliament has no power to take away that right, except within the terms of the constitution itself. So that the question is, can Jamaica nevertheless go and agree to an international agreement under which it will incur cost enforcing the constitution to protect the environment? So that is what I try to argue, that we need to reconcile the terms of international trade agreements, investment treaties, with the constitutional obligations of states. Unless we do that, the conflict will persist. And developing countries in Africa, in the Caribbean, are going to be the losers because they are going to be sued. And international arbitration is very expensive. And it will be difficult for states to be able to defend them using public funds. So thank you for that question. It's a very important one.
Yes, Dr. Allen.
Yes, good morning again. And Joel is perfectly fine, Marcus, as you know, and Dominic. So thanks again, Dominic, for such an interesting presentation. What I'm gleaning from this, and I'm not qualified to sort of cross-examine you or anything like that. What I'm getting from your presentation is that there is a high level of interactivity between the development of the signing of these trade agreements and potentially innovation, the innovation building of countries or the capacity development of countries, as well as an interdependence between the two as well. So here's what I'm wondering. Here's my question to you. To what extent do you think, if countries build their innovation capabilities, that it will increase their bargaining power to be able to negotiate better trade agreements and therefore help themselves to advance on the trajectory of development?
Thank you. Again, that is a very important question and is dear to me. You will see that if you look at, I don't have the figures here, but investment flow, say, between African countries and Europe, for example, it's a one-sided thing where investment flows from that part of the world to the continent and even to the Caribbean. Okay. And that is partly because we have not been able to grow our local capacity such that we can be global. We can also really be described as, we can have multinational business entities, multinational business enterprises that can operate anywhere in the world to take benefit of the investment treaties that we signed to. So, and that is where having innovative business policies that build local capacity. You see, when we say foreign investors, who are foreign investors? They are just local somewhere who have the capacity to do business somewhere else. That is what makes them foreign investors. And so if we don't build the capacity, foreign investors don't come to develop your nation. They come to do business. And you will benefit somehow in the process. But you cannot sustain national development based on just foreign investors operating within. So if we were able to build the local capacity, we will be I think the bargaining power will change. Because if you are needed, say in any part of the world, because of your capacity, you have the clout to say your government will have the clout to be able to say, we do not want our businesses to be subject to this type of protection. If you don't have that, then of course, it means that it becomes a one-sided thing where you don't really benefit from those agreements. So indeed, I will argue there's that connection between investment treaties, trade agreements, and business innovation. It's just about whether we are building the capacity to take advantage of them. And if we do that, I think the bargaining, power will be at least, if not equal, will be reasonably up there for African countries, Caribbean countries. Thank you.
All right, thanks for that. So we really need to focus on building capacity. Otherwise, we're just going to be signing trade agreements that allow others to invest in our country or to sell their products in our country without, or in our countries, without us actually exporting. And there is quite a lot of, more than enough data and research out there that shows us that the countries that transition from developing to developed country status are those that typically innovate and those that are selling products that the world needs. So we really have to focus a lot more on building those products domestically, building that capacity domestically in order to optimize on the trade agreements. Otherwise, the trade agreements are an academic, it will become an academic for us, but central for those who would seek to sell their products in our markets. And that is the reason why us growth perspectives is one of the reasons why we are here to sort of guide governments and companies in terms of how to internationalize and how to sort of structure their markets in such a way, build the capacity in such a way that their bargaining power increases and they can optimize on the trade agreements, trade treaties that they sign, and so on, and to benefit their people, right, at all ends of the spectrum, not just the high value end, but the mid value, the lower value folks. Everybody benefits from innovation. Thank you.
Thank you.
Yes, as we talk about innovation, of course, right, as you mentioned, Joel, focusing on that aspect is so critical for developing countries, right? Historically, when we think of intellectual property, it's been really the majority of the developed countries who have obviously been able to accelerate on the strength of patents and trademarks, and domain names, designs and these areas, right? And, our developing countries in Africa and in the diaspora, in the Caribbean included, have been strong in the performing arts, music and art and craft and culture, you know, and costume and in folklore and that, you know, kind of thing, which has not always gotten the kind of protection, you know, and investment as other areas, you know. And in fact, what we find from this region oftentimes is that because of the performing arts requiring access to markets of individuals as opposed to goods, then oftentimes there are existing barriers that can and are imposed in terms of travel restrictions, you know, visa requirements, different work permit requirements, and these kind of things, you know, which would not be the same as the movement of goods, you know, involves. And so these are also challenges, you know, but of course, being able to navigate the markets, right? Being able to know, you know, where the strengths are, you know, where we can maximize the creative economies of scale and brand strength that we have, you know. And certainly I think right now too, you know, if we look at the global music scene, we see that African music, Caribbean music, Caribbean performing arts,
I'm in the middle
are
of
quite
our
strong.
webinar, but I said, let me answer you.
And
Can
so
I call you back and remind me what?
We would want to be able, you know, to strengthen these connections and these networks, you know, sometimes again, certainly from this neck of the world, you know, we perceive the northern markets as being predominant, right? Which they are, but of course we oftentimes don't appreciate, right? As I say, the wide continental market that we have in Africa and what we have in common, you know. So a lot is available, and I know that Joel and the team are, you know, ready to assist with opening up opportunities, you know, for Caribbean enterprises in Africa, and of course, vice versa, right? We can have investment not only of states and foreign companies and multinationals, but again, amongst ourselves too, south to south investment, right? That can facilitate investment in our priority areas in strengthening our economies of scale and our creative industries and so forth. So, any words on that, Dr. Dagbanja, in terms of your work? Have you looked at anything in the context of creative arts, you know, movement of those kinds of assets, you know, what we call intellectual assets across the Caribbean and the diaspora? Any perspectives on that you want to share?
Yes, I have my research hasn't specifically looked at that area, but broadly, I think the issues of the connection between domestic policy and international investment treaties is all embracing and will include this sector as well, because it's about movement, for example, of cultural products, and to what extent is, say, let's say Australia, for example, is open to the reception of cultural products. It's very difficult, and we have had stories, for example, where people carry, let's say, local food products all the way, let's say, from Ghana, and then they get to the airport and then they collect and dump them somewhere. Say yam, that is not an area that you were specifically referring to, but say you cannot bring yam into Australia, for example. You have to peel it and then get it frozen before you can get it into the market. So yes, I think you know, the markets are not necessarily as open to receive artwork, cultural products from our part of the world. And the broader issues of domestic law and policy and investment law that I look at, in a sense, embraces some of these issues, although I've not done research directly, specifically looking at art and culture and international investment law.
Right. Yes. Well, yes. I mean, yes. I think it's one of those areas, you know, that I say we tend to have a lot of brand recognition in, you know, certain Jamaica, strong brand in that sphere, and as we know, Africa too. Let's say, you know, And so that's one of those areas I think we have a competitive advantage. And certainly, with more investment on our side and innovation on our side, we certainly would be able to have increased access and penetration in some of these foreign markets and be able to, secure more from, these kind of treaties as well.
Okay.
All right. So any questions? The floor is again open. Any questions or any comments for Dr. Dagbanja, for Dominic?
Just a comment.
Well,
Dominic, I wonder if you could just stop sharing your screen.
Okay, at this time. Okay.
Yes. And then Marcus, perhaps we can take a couple more questions and then close off. I think people are being a little shy this morning. I'm not sure why, but we'd love to hear from other folks on this call.
Yes, questions or comments, anything of interest, any perspectives you want to share, please feel free. Right. Well, you heard Dr. Dagbanja talk about, of course, the right to development, right? Right to development. And it's also, I think, very important in the whole context too, right? So the challenges that come from also navigating that, against the investor oftentimes, right? May have, particular nuances in terms of being able to navigate, those aspects. So I think what it really means, and I'm going to ask Dr. Dagbanja, is of course to know your market, right? Know your market. If you are seeking to enter into a foreign context, whether through goods, through services, etc., you want to be able to facilitate or to have done for you some research around that market. What are the access requirements, the entry requirements? What are the standards for goods and or services? And of course, trying to see sometimes in these agreements, in these treaties too, there are, certain incentives that are there, right, based on international cooperation in the area of culture, for example, in the area of innovation. We've seen several of this in the area of film production that would require, co-production involving a enterprise or a national on the Caribbean side, or the African side, and a national on the investor, other member state side, right? And so sometimes again, these treaties can be creative in that respect, but not many people always know about these opportunities as well, so yeah, of course we can think of also non-trade barriers as well too, right? To trade also. And so these things, of course, are oftentimes what makes persons either, cautious about going overseas, right? Or maybe, let's say, feeling that, it's not something that they can really achieve and accomplish, So yes, I see Mr. Wright typing in the chat. Mr. Wright, you want to say a few more words or comments on your points?
Sir, I was just thinking that, part of the lack of development or underdevelopment is the whole question of land tenure, the whole question of housing. I'm speaking in Jamaican terms, and the more that we seek to get foreign direct investment at the cost of repatriation of profits, and there's a significant focus on domestic capital formation, because that's really where I think some of that focus should be. And if you look at the SWAT of Jamaica, we have our human resources, which we don't really view as human resources. We view them as rich people and poor people are criminal, and in that context, we don't look holistically at our human resources as human resources, in my humble opinion, and treat with them accordingly, to give them education and to give them the right to passage from the conflicts that arise due to the lack of education. And I don't know that there's any constitutional or legal consequence for those shortfalls and maladies in our system.
Well, yes, I think some of those are certainly larger issues, you know, but Dominic, any thoughts on how these things, you know, can be impacted positively, negatively through the treaty framework or other human rights?
The question of land tenure is that well, domestic constitutions might limit the nature of land ownership by foreign investors or foreign nationals, for that matter. And I know the Constitution of Ghana does. And we've referred to the case of Zimbabwe, where the government passed legislation based on a new constitution, taking land from foreign investors and giving them to the rightful owners. And that became a basis for international arbitration. So if, for example, you open your country for investment in the real estate sector, that borders on land ownership, land tenure, and so forth. And that has implications for the protection of ordinary citizens, because investment in the housing industry may come at a cost that individuals may not have the capacity to own those. Majority of the individuals might not have the capacity to own those houses. But it might also come with implications of people who actually own those lands, depending on how careless the government may be. They move from lands that belong to them in order to give way for foreign investment and so forth. So yes, there is that potential for conflict between land ownership, land tenure, and international investment treaties, to the extent that this sector is open for investment activities. And it is a huge area that needs to be given attention, because sometimes if the regulatory regime is so loose, it means foreigners can easily acquire land and own them contrary to domestic law and policy, and particularly in the context of African countries, say Ghana, for example, where we have customary land tenure system, and then we have, you know, the common law system or the legislative system for owning land and so forth. And there's a risk that customary ownership of land can lead to a situation where the people who should be occupying the land are displaced and put in the corner somewhere, while lands are being given out to foreign investors to invest. The sector, it is a very sensitive area that states really need to take seriously and see the extent to which and as our brother has said, we need to grow the domestic capacity to be able to invest in the sector, especially in the land area. We need to be able to grow domestic sector domestic capacity to be able to invest in that sector. In Australia here, I mean, they don't allow foreign investors. They put the national interest at the center of the entry and admission of foreign investment. But I think in our part of the world, the system is too loose. And so they can go into any sector, and the national security implications that come with that are hardly given the needed attention. Thank you.
Thank you, Dr. Dagbanja. All right. So I'm thinking, Dr. Dagbanja, you know, we've heard a lot about, you know, through the African Union, right? The moves to somehow integrate the diaspora, right? And to facilitate the return to the motherland, right? Through investment, through opportunities, through land ownership, through immigration, facilitation, and that kind of thing, right? So are there any sort of model agreements or even, I don't know, MOUs, I don't know if there are any treaties, perhaps not, that specifically focus on the diaspora and that kind of investment in Africa?
Thank you. As you know, Ghana has been leading the conversation around the return of the children of Africa back home. If we say they are the children of Africa, then they are coming home. And therefore, they should not be subject to the usual laws that will apply. But at the same time, they will be coming holding on to the citizenship of other countries. And so how do we treat our children, our brothers and sisters who come? Are we treating them purely as brothers and sisters who are returning home? And that the domestic laws and regulations that apply to citizens, say in Ghana, will apply to them? I am not aware. It is a novel question that you have raised. And I don't know how the nature of the legal regime that is handling issues of this nature. But again, maybe what African countries are doing in particular is to make it easy to acquire citizenship. And so if you acquire citizenship, that gives you some flexibility. It makes it easy to be able to get the legal protection that is available domestically. I think Ghana has been doing that. And so maybe that is one way that things can be made easy for African diaspora to be able to return and invest. But I'm not aware of the nature of the legal regime that is specifically designed to look at the situation of African diaspora willing to do business in Africa. And I think that the rules cannot be the same if we want African diaspora to do business on the continent, then there is a need for rules to be much more friendly, I think, towards them than they will usually apply to the typical foreigner seeking to do investment in Africa. I will take this as an assignment to see what is the nature of the conversation around the rules governing African diaspora doing investment trading on the continent. Thank you.
All right, so thank you for that. All right, so all right, if there are no other questions or comments, which I don't see any hands up, I want to thank Dr. Dagbanja, really engaging presentation, and thanks for being open to so many questions, and different perspectives. So I'm going to hand over to Joel to do the final wrap up, and thank you.
Sure, John, come on.
Thank you very much, Marcus. Thank you, Dominic. I see that Charlie Francis's hand is raised, so let us just give him the opportunity to ask a question before I sort of close out.
Yeah, just a quick one. I actually was struggling to get my my speaker system connected. This is a question about a project that I have become recently familiar with. It is spearheaded by a gentleman, Ambassador Tunde Adetunje. I want to know if you're familiar with him, familiar with his program and project. And to say that I'm asking this question because we are currently engaged with him, speaking something similar to what you have been discussing, the diaspora, under a project that he has called Stemming the Brain Drain, I think it is, Bridging the Gap and Building the Bridge for the relationship between Africa and the diaspora. And he is now interested in bringing this program into the Southern Caribbean, and that's how come we came into contact. Any familiarity with this and any opinion on that line of programming?
It sounds like the person must be from Nigeria, from the last name that you mentioned, but I haven't heard about the person at all. I am aware of the African ADDI, Africa Diaspora Development Institute. I don't know whether you've heard it.
I think that is related to the Africa Heritage Foundation, which is
Yes.
incorporated in Atlanta, Georgia, and
Yes.
maybe the same institution. Okay, thank you. Yeah.
Yeah, so it sounds familiar, but the one that you are specifically referring to, I have not heard about the person at all. And I would love to be able to read about who the person is and what they are doing. But I'm aware of the Africa Diaspora Development Institute, which is also championing the whole idea that the development of the continent lies in the hands of Africa and its diaspora, and that there is a need to pool resources, efforts together to contribute towards the development of the African continents. But I haven't heard this particular one that you are referring to.
Okay, if you allow, I will forward the information to Dr. Joel Allen so that we can.
Yeah, that would be very, very helpful. I would like to read more about that.
Yes.
Yeah, thank you.
All right, thank you very much, Charlie Francis. I see another hand. Daniel C. has raised his hand. I just give him just 1 minute for this one. Go right ahead, Daniel.
You can be sure I will stay as long as there are questions. I'm happy to engage with brothers. For the most part, the African population here is nearly nil, so it's good. It's like going back home to engage with you. So,
so my question to you, Mr. Dagbanja, is: do you think developing countries should just focus on specialization and become less dependent on foreign direct investments or treaties? That's the question for you.
Thank you. I don't think there's any country that develops by being necessarily open to foreign investment. And the whole idea that development, private investment is the engine for growth and development is a bit of questionable. There's no doubt about the contribution that investment, the private sector can make. But I think that it is a bit of a problem to run an entire country with the hands being open to receive foreign investors. So yes, I think each country needs to, in Africa, in the Caribbean, needs to identify where its area of specialty capacity is, and to try to leverage, capitalized on that for development. But I don't think that, and that is the problem. And indeed, Dr. Kwame Nkrumah said it in one of the books, which I quoted in my book, that how can the northern part of Ghana develop compared to, say, the southern part, where the resource for foreign, the resources that attract foreign investors are, that the southern part where we have gold, diamond, those extractive resources are more likely to attract foreign investors than the northern part, which is Savannah. And so, yes, the question of specialization, if we have the resources lying underground there, then I think we need to be building our capacity towards being able to extract those resources. That is where our capacity is, and that is where the question of innovation comes in. We have the resources, and governments should be championing their resources towards building local capacity to be able to extract the resources. Then they can also send those expertise elsewhere to extract. But if that is our area of endowment, and we are not building capacity, then we will continue to rely on foreign investors. So it is a legitimate and important question that you have raised, that we need to be specializing in the areas that we have the capacity. Just as like my brother Marcus was saying, that the arts and culture industry, in the case of Jamaica, for example, okay, so how are we building the capacity in that sector so we can also export the skills and the resources elsewhere? So I will support that proposition that we need to be specializing and building innovation in the sectors that we have the capacity. And in this case, in Africa in particular, an aspect will be the resource sector, so that we minimize the extent to which we need to rely on foreigners or foreign businesses to come and extract the resources and take away, of course, they put in their capital, they use their technology and all of that. And by taking all of the cost of extracting, nothing will be left for the state. But if we have a local business that can do so, they will not repatriate the money or the resources. It will remain in the country. Thank you.
And thank you, Dr. Dagbanja, or Dominic, for me really, and for us, for a very interesting discussion on international trade treaties and interaction between that and innovation, business innovation, which we have concluded that in order for developing countries to sort of increase their capacity or their ability, their bargaining power, they need to innovate more and, of course, position themselves to be able to negotiate these trade treaties in a better way so that their citizens are not put at risk as a result of sort of signing trade agreements. And of course, building the capacity allows them to trade something. I mean, when you sign an agreement, you do need to have something to trade, right? Not just to be on the receiving end of the trade, but to be able to export goods and services, whether they be cultural goods and services or just, non-cultural type of goods and services, and so on. And thanks as well to, thank you for your time. It's now, by my count, it is almost 12 o'clock in Perth, Australia. But guys, when you're having fun, I know that you're pretty passionate about what you're doing. But we're so indebted to you and your family for, spending such time with us at this time of the night. I hope you get up early tomorrow morning to go to uni and so on. And thanks to Marcus Goffe, our very own technical consultant in the innovation practice, and you, Dominic, are in the strategy practice of growth perspectives. Marcus had you on cross-examination there for a little while. And between Marcus, Charlie Francis, Norman Wright, and Daniel C., they have given you some homework.
Yes.
You have to go now and do some more research. So I'm not sure that I'm hearing the sense that there is another book coming based on the research that you're going to do from this.
Certainly. We're in the business of book production.
Yes, indeed. And in talking about book, I want to just invite the audience to hop on to Amazon and have a look at where they can purchase your book, your most recent book, which is entitled The Investment Treaty Regime and Public Interest Regulation in Africa. It's published thanks to Oxford University Press. So for those of us who are interested in acquiring the book, feel free to hop on to Amazon to grab a copy of it. It's really a good book to keep in the library as we talk about South-to-South trade and as we seek to build our capacity to export and innovation capacity. So we also invite those who are interested, countries and companies that are looking for advice in terms of how to navigate global trade and how to negotiate international trade treaties, to reach out to us at info@growthperspectives.com. You have access to the likes of Dominic, who has worked on 4 or 5 continents, advised the UN Conference on Trade and Development, and most recently the Australia Ministry of Foreign Affairs. And you have people like Marcus Goffe as well, who has been an advisor to many, including development agencies in Jamaica and the Caribbean, and was formerly deputy director at the Jamaica Intellectual Property Office. So we have more than enough resource and skills here for persons for companies and countries to benefit from. And we really want to see a difference, right? We are doing this not because we are looking to make money. We do have bills to pay and so on, and money helps to sort of pay those bills. But we're doing this because we want to make a difference in the world. We want to make a difference in our neck of the woods, in Africa and the Caribbean and developing countries elsewhere. We really want to help to build that capacity so that we can see a transition, not just for us, but for the generation to come, right? We need to change the trajectory. So I want to thank you. I thank as well Kismet Cooper and Daniel J. Campbell for their support, and others who have been part of the ecosystem that has made this webinar possible. And last but not least, I'd like to thank those who have signed on to the webinar today. And thank you for your questions and comments. And thanks to those who we expect to watch it on YouTube. And feel free to like the webinar on YouTube when it's put up later on our YouTube channel. So thanks once again, and have a fantastic day for those of us on this part of the world. And for you, Dominic, have a good night. And for those in Australia and New Zealand and so on, have a good afternoon, a good night. Take good care and walk good.
Thank you. Thank you very much once again to you and Ms. Kismet Cooper. I've been working with you all of this while. And thank you, my brother Marcus, and everybody for taking part.
Thank you. All the best.
Thank you.
All right. Keep well and stay
All right.
blessed.
Thank you. Enjoy the rest of your day.
Yes, you too.
All right. Bye-bye.
Thank you.
Bye.